All right, everybody. It's Sunday, May 4th. May the 4th be with you. Time for another court order. We got one on Friday about Donald Trump's executive orders. One executive order against a law firm named Perkins Coie. Coie? I'm not sure how to pronounce that. C-O-I-E. I've heard it pronounced both ways. This came from Judge Beryl Howell from the District Court in Washington, D.C., and she found his executive order against this law firm to be explicitly, clearly, unambiguously, and completely unconstitutional, and put a permanent injunction in place. One thing that I wanted to mention, I did a 20-minute long video on my YouTube page Thursday or Friday morning about the order that we got from a Trump-appointed judge in Brownsville, Texas, for the Western District of Texas, explicitly finding in no uncertain terms, with zero ambiguity, that Donald Trump's invocation of the Alien Enemies Act is unlawful, and he is no longer permitted to deport any immigrants in the Western District of Texas pursuant to the Alien Enemies Act. These two judges in particular, but this is true of all the district court judges. District court's trial court level, then you get the circuit court, the appellate court, and then you get the Supreme Court in the federal system. They are writing very lengthy, extremely detailed decisions on these issues. And in doing so, they are making it exceedingly difficult, not impossible, but incredibly difficult for the higher courts to overturn these decisions or come up with findings that are different than the district court level judges are finding, the trial court judges, the ones who are actually hearing the evidence. And so there's the Alien Enemies Act decision that was 35 or 40 pages long, written in tremendous detail and made innumerable findings of fact that the Trump administration had not met the two statutory requirements that need to be present in order to invoke the Alien Enemies Act. And that judge found that to be unlawful. This decision from Judge Beryl Howell about Trump's executive order against the law firm Perkins Coie, her decision is 102 pages long. So I'm not going to cover the whole thing. I'm going to hit the high points. And I'm just going to read the beginning of what she wrote here, because it's really important. You know, it's a really important distillation of the lawless nature and the unconstitutional nature of the Trump administration and his supporters. They don't like that due process applies to everyone who's present in the United States, whether they are a documented citizen or not. And so they just want to ignore that part of the Constitution. Donald Trump has explicitly stated that he is not going to obey the Constitution when it comes to concepts such as due process for undocumented citizens. So let's begin. No American president has ever issued executive orders like the one at issue in this lawsuit, targeting a prominent law firm with adverse actions to be executed by all executive branch agencies. But in purpose and effect, this action draws from a playbook as old as Shakespeare, who penned the phrase, "The first thing we do, let's kill all the lawyers," from Henry VI. There were a lot of Henrys back then. When Shakespeare's character, a rebel leader intent on becoming king, hears this suggestion, he promptly incorporates this tactic as a part of his plan to assume power, leading in the same scene to the rebel leader demanding away with him, referring to an educated clerk who can make obligations and write in court language. Eliminating lawyers as the guardians of the rule of law removes a major impediment to the path to power. Even Justice Stevens, legendary Supreme Court justice, in explaining the import of the same Shakespearean statement to be, quote, that disposing of lawyers is a step in the direction of a totalitarian form of government, close quote. The importance of independent lawyers to ensuring. So here's the other thing, and this will become readily clear. The current Trump administration doesn't have any independent lawyers. All of the attorneys, or almost all of the attorneys that are working in the Trump administration or representing the Trump administration in court, are in those positions because they are ideologues. They are MAGA, which means that their fealty is to Donald Trump and MAGA before the Constitution and the rule of law. Period. He is not getting any competent, independent, objective legal advice from any of the attorneys around him. And the impact of that is there have been 4 law firms who are fighting these executive orders. There have been a dozen or more others who have just capitulated and worked out a deal with Trump and his administration, doing away with their DEI programs, pledging $40 or $100 million in pro bono fees so that Donald Trump will leave them alone. And Judge Beryl Howell, in her decision, she made a comment along the lines of the firms that are standing up to Donald Trump and fighting these executive orders will be lionized in history. They will be remembered as heroes who stood up on principle for the Constitution, for the idea of America, and stood up against authoritarianism and totalitarian rule. She said the firms that capitulated will not be so remembered. Yeah. Why do you hire a law firm to fight on your behalf? If the entity on the other side is the federal government, how can you go to one of these firms that capitulated and expect them to fight on your behalf against the federal government when they wouldn't even fight against this administration on their own behalf? Against an executive order that is clearly, unambiguously, blatantly unconstitutional. And these law firms wouldn't even fight on their own behalf against that. In the legal world, I'm sure I've said this before, lawyers and law firms, it's like your talent is important, your skill level is important, your advocacy is important. All of those are secondary to your reputation within and without the legal community. Your reputation is absolutely everything. And these firms that capitulated have done unimaginable damage to their reputations, but they have done that in a transactional way because they think that that damage was worth it to their economic bottom line. Money. Yeah. Anyway, back to the opinion. The importance of independent lawyers to ensuring the American judicial system's fair and impartial administration of justice has been recognized in this country since its founding era. In 1770, John Adams made the singularly unpopular decision to represent 8 British soldiers charged with murder for their roles in the Boston Massacre, and claimed later to have suffered the loss of more than half of his practice. He said, "I had no hesitation," he explained. "Counsel ought to be the very last thing that an accused person should want for in a free country, and the bar ought to be independent and impartial at all times and in every circumstance." When the Bill of Rights was ratified, these principles were codified into the Constitution. The Sixth Amendment secured the right in all criminal prosecutions to have the assistance of counsel for defense. The Fifth Amendment protected the right to the aid of counsel when desired and provided by the party asserting the right. Alexis de Tocqueville took note of this and insightfully remarked, "The authority entrusted to members of the legal profession is the most powerful existing security against the excesses of democracy." Donald Trump's re-election was an excess of democracy. That's a fancy late 1700s way of saying it's fucked up. The electorate fucked up. and that is the excess of democracy. The Supreme Court, too, has recognized the importance of lawyers to the functioning of the American judicial system, since an informed, independent judiciary presumes an informed, independent bar. This is so because Congress may legislate, the president may implement or execute the laws, and the courts may adjudicate, but only the lawyers can prepare and submit the great issues of human justice under law in such a manner, and from that, courts in the ultimate be effective. Absent their crucial independence, lawyers would become nothing more than parrots of the views of whatever group wields governmental power at that moment. This case presents an unprecedented attack on these foundational principles. On March 6, 2025, President Trump issued Executive Order 14230, entitled Addressing Risks from Perkins Coie, LLP. By its terms, this order stigmatizes and penalizes a particular law firm and its employees, from its partners to its associate attorneys, secretaries, and mailroom attendants, due to the firm's representation both in the past and currently of clients pursuing claims and taking positions with which the current president disagrees, as well as the firm's own speech. In a cringe-worthy twist on the theatrical phrase, "let's kill all the lawyers," Executive Order 14230 takes the approach of, let's kill all the lawyers that I don't like, sending a clear message. Lawyers must stick to the party line or else. So, yeah, using the power of the federal government to target lawyers for their representation of clients and avowed progressive employment policies, DEI, in an overt attempt to suppress and punish certain viewpoints, however, is contrary to the Constitution, which requires that the government respond to dissenting, unpopular speech or ideas with tolerance, not coercion. That, however, is exactly what is happening here. For this reason, and those reasons explained more fully below, Executive Order 14230 is unconstitutional, and the findings and instructions to executive branch agencies issued in its sections 1 through 5 cannot be allowed to stand. Accordingly, the government had filed a motion to dismiss this lawsuit. Accordingly, the government's renewed motion to dismiss and for expedited judgment is denied. Plaintiff's motion for summary judgment and declaratory and permanent injunctive relief is granted. And then the opinion is broken up into several different sections. She gives kind of an overview, and I'm not going to cover all of those because it's 102 pages long, and I just finished page 5. One thing that she singles out that I thought was of critical, well, there's several things. The first thing is that within this executive order and the other executive orders that Trump has issued against law firms, he says they are national security risks. Unless and until they capitulate and make a deal with him. Then they're no longer security risks. If you disagree with me, you're a national security risk and I'm going to punish you. If you let me punish you through an agreement, then you are no longer a national security risk. So are they or aren't they? And Donald Trump said in a speech, he's like, and which is cited in this opinion, have you seen all these law firms kissing my ass and making all these deals? They're making these deals as an admission of guilt, that they did bad things, according to Donald Trump. So take that with the first thing that I just said. He's alleging that they're national security risks. And if they make a deal with me, they're admitting that they did bad things and that they pose national security risks. But if they make a deal with me, then they're no longer national security risks. Nothing else has changed. It's all the same people, all the same employees, all the same attorneys. They're national security risks unless they make a deal with me. And if they make a deal with me, they're admitting wrongdoing, which would seem to confirm that they're national security risks. Yeah, that's what we call circular logic. And so she goes through the history of the firm. It's a top 50 international law firm. The Perkins Coie top 15 clients by revenue, and many of the firm's other large clients currently hold federal contracts and subcontracts with the federal government and compete with such contracts. So Perkins Coie, their top 15 clients have business with the government. And she goes through an exhaustive list of, because this executive order was in effect for a week before they went to court and got a temporary restraining order enjoining this. During that week, they lost hundreds and hundreds and hundreds and hundreds of thousands of dollars of income, if not millions, from clients who were like, you have this executive order against you. You can't represent me in front of the government, so I have to go find another attorney. And which demonstrated damages, frankly, which was important to this. In 2019, the firm also adopted the Mansfield Rule, which aims to diversify the leadership of law firms by broadening the candidate pool for senior management positions. To do so, the Mansfield Rule requires that participating firms certify that women, lawyers of color, LGBTQ lawyers, and lawyers with disabilities comprise at least 30% of the candidate pool for significant leadership roles, senior lateral openings, and promotions. This is what the right doesn't understand about DEI. DEI means expanding the candidate pool for positions, whether it be entering college or jobs or senior management. You're just expanding the candidate pool. You're making sure that you include in the candidate pool women, Black people, people of color, LGBTQ people, and disabled people. You're not guaranteeing them a job based on their status. You're just including them as applicants, qualified applicants, in a process in which they otherwise previously were never even included in the application process, let alone being able to get some of these senior positions. I mean, because to people on the right, it's like, if you get on a plane and there's a Black pilot, they automatically assume that that Black pilot got that job despite being wholly unqualified for that position. If they see a white man as pilot, they assume that that person is wholly qualified to have that position. Anything other than a white man in any position of power in any organization means that that person is not qualified by definition for that job because they're not a white man. And I did a long TikTok yesterday about look at the level of confidence level of competence that we have across this executive branch that is staffed almost entirely by white men. Hegseth and Waltz in the DOD with their signal chats. Marco Rubio striking deals with foreign dictators to imprison U.S. citizens. Anyway. So the past history, the problems that Trump had with Perkins Coie is they used to employ Mark Elias, who is now an election law attorney with his own firm. He won 60 out of 61 lawsuits brought by Giuliani after the 2020 election. In 2016, Mark Elias and other former members of a practice group within Perkins Coie called the Political Law Group represented Hillary Clinton in connection with her presidential campaign against Donald Trump. As part of this representation, these former Perkins Coie attorneys engaged the services of an opposition research firm, Fusion GPS. Fusion GPS worked with Christopher Steele to get the Steele dossier. That's how far back this goes. It goes back to 2016. Elias left Perkins Coie in 2021, went on to form his own firm, and none of the firm's attorneys involved in the engagement of Fusion GPS have been employed by the law firm for at least the past 3 years. They all left to do other things. Another former Perkins Coie attorney, Michael Sussman, who was not part of that group, but who had been retained due to his cybersecurity experience by the Clinton campaign after the campaign's emails were hacked, After being indicted, he was in. So remember, when Trump was going out of office, he had appointed this special prosecutor named John Durham to investigate the Russia hoax. John Durham spent 5 years doing that, brought 2 prosecutions, and lost both of those trials. One of those trials was against Mark Sussman. He was indicted by John Durham in 2021, and then he was acquitted on May 31st, 2022, on the charge of lying to the FBI about links between the Trump organization and Russia. So this shit all goes back to Russia, impeachments, his criminal cases, all of that crap. And so the government stated clearly, we are targeting this firm because of its past associations with Mark Sussman, or with Mark Elias and the Sussman guy, and because they're engaging in illegal DEI practices. And well, I'll read this other thing because on March 24th, 2022, then former President Trump filed a lawsuit against 31 individuals and entities, including Perkins Coie, alleging that they maliciously conspired to weave a false narrative that the Trump campaign was colluding with Russia, including by falsifying evidence, deceiving law enforcement, and exploiting access to highly sensitive data sources, among other allegations, and they sought $24 million in damages. Donald Trump was represented in that lawsuit by Alina Habba. Yeah. The lawsuit was dismissed with prejudice, meaning they can't bring it again, on September 28, 2022, with the court finding that the lawsuit had no merit. As a result of this lawsuit, President Trump and one of his attorneys were sanctioned over $900,000 for, among other things, bringing a frivolous case in order to dishonestly advance a political narrative. They had to cover like $1 million worth of Hillary Clinton's lawyer fees. Anyway, this is a super interesting opinion. It's really dense. I doubt many people are going to go read the whole thing. But Judge Howell found that and she also goes through an exhaustive list of like Truth Social posts from Donald Trump, Twitter posts, and things that he has said in speeches and interviews about this law firm, and basically saying, if you reelect me, I'm going to go after the lawyers. I'm going to go after the lawyers who did all of this Russia Mueller investigation shit, all the ones who indicted me. I'm going to go after the people at the FBI who, got the search warrant and then searched my home, Mar-a-Lago, where they found, hundreds of classified documents that he lied about having. And she goes through all of these statements in this decision, and it's like, he said this is what he was going to do, and what he is doing is blatantly unconstitutional. For everyone involved, it violates their First Amendment rights to speech, to expression, to associate, hire the attorneys that you want, and most importantly, seek redress against the government, sue the government, represent clients against the government. It violates all of their Fifth Amendment rights to counsel, and it violates their Sixth Amendment rights as well. And she's like, again, it's like, as with the Alien Enemies Act decision, it's not a close call, okay? When you go through the analysis, it is not a close call. It just isn't. She's like, he said this for going back to 2018, that he fucking hates these people, and this is what he's going to do to them. And now he's doing it. This is, you're not allowed to do this. And so, but again, as with the Alien Enemies Act decision, which was written by a Trump-appointed judge, this decision is written in a way, hang on, shit, I'm out of binder clips. It's written in a way that's going to make it virtually impossible to overturn this decision. So, by the higher courts. Anyway, if you're still watching, please click like, and what's the rest? Oh, leave a comment, subscribe to my page. It's free. Yeah, like that. I hope everybody enjoys the rest of this amazing, beautiful Sunday afternoon, and be safe, everybody.